The meeting in order. Start with Pledge of Allegiance. Roll call, please.
Yosher.
Here.
McCardle.
Here.
Barrington.
Here.
Allen.
Here.
Charts. Smith. Savers. Rice.
Here.
Okay, we have a quorum. All right. First reading on ordinance 0202106, creating zoning regulations for cannabis establishments.
Before we get started, can I say something?
Sure, go ahead.
I've had a lot of people ask me about this. They think this is something the city's just trying to sell marijuana. But this was a state vote in the last primary where the state passed it, and it's nothing the city's doing. We're just following up with what the state election did. It's not that we're trying to sell marijuana as a city. We're just trying to put the rules and regulations in effect so it's done properly in the way we want it done in the city of Mitchell. So it's voted on by the people of South Dakota, not the city, not the people of Mitchell.
Right, and you'll hear that. This relates to IM-26, which was the medical marijuana portion of the state law, that when it goes into effect, July 1st, whether you like it or not is irrelevant. It is going to go into law. People will be able to have medical marijuana. What we're trying to do is limit the areas where this can be sold, grown, processed, and that's what this zoning ordinance does. So with that, Mr. Johnson, you want to take it?
Yeah, I think that sets a good stage. And I think to add on what Kevin said, if we don't put anything in place, then it's essentially the Wild West, and you know, people can do anything that we haven't prohibited. So I think it is important that we get some kind of regulations on the book, even if we have to come back at a future date and make additional changes to them down the road. But starting off here, I'll try to do a brief summary of the zoning portion since we're considering that first. The first couple sections are pretty standard with the intent and the basic definitions. The zoning regulations are really about where these establishments can locate, and there are sections for each type of cannabis establishment. There are 4 different classes. Those are cultivation facilities. So you have cultivation facilities, testing facilities, product manufacturing, and then dispensaries. We've got different sections for each one of those, and you can see that the districts can be different for each one as to what's permitted and what's conditional. The way that we set it up here, it's really going to be the same businesses for each type of business, with a few extra regulations or restrictions on the dispensaries that would be doing retail sales to the general public, or I guess the card holders in this case. So for the zoning districts where it would be permitted, that's highway business and TWC, transportation, warehouse, and commercial. And the central business district would be conditional use, so it could potentially locate in those locations as well. And then when you go to the dispensaries, the additional restrictions that I mentioned would be buffer zones around certain types of other land uses. In our ordinance, we state 300 feet from basically schools, churches, childcare, and a couple of other types of businesses. And then there would also be a requirement that each dispensary be at least 1,000 feet away from another dispensary, so you don't have a cluster of them in a single location, and you've got just block after block of dispensaries. Under our ordinance, we've got the 300-foot buffer around most of those other land uses. When you look at the zoning map that we prepared just for kind of informational purposes, it's not exact, so down the road, it might be a little bit different, but this will give you a pretty good idea of where those buffer zones would prohibit a certain type of business. And as you can see, just one second here, John, as you can see, the buffer around the school zones on that map is actually quite a bit larger. That would be a 1,000-foot buffer, not a 300-foot buffer, and that's because the state law itself requires a 1,000-foot buffer from schools. So our map shows that 1,000-foot buffer around schools instead of 300 that we would set. John, I don't know if that answered your question, but I'll.
No, as we go, we have a question, should we wait till the end, interrupt?
I'd say now's a good time if you
All
got
right.
one.
What would happen is if a property is bisected by the 300 foot? I mean, the building is outside 300 foot, but the sidewalk's within the 300 foot.
Right, yep. So
Is that allowed or not allowed?
it's going to depend. So the 300-foot, as you see on this map, and as it's calculated under the ordinance, is 300 foot from property line to the end of the buffer zone. So it's not necessarily from a building, so if there was a school itself sitting on a large lot, as you can see, like with Mitchell Christian there, it's 1,000 foot from the edge of their property, even though the school is kind of centralized in that large lot. So that's going to extend that building out. And I think that more to the question that you're getting at is if that buffer crosses over onto another lot, it's going to be crossing onto that lot, the property line itself, and not the building where that dispensary or other business might be located on that lot. So that buffer zone might just barely touch the corner of a lot in another district, but if it touches the lot, then it's going to prohibit anything on that lot. Now, that doesn't mean that, you've got significant chunks of land over there across from Mitchell Christian. You could have something get parceled off at a later date that might be outside of that buffer, but as long as it's one lot, it's going to be treated as one lot. So,
one other clarification just for the general public, Stephanie Elwine, City Administrator for the City of Mitchell, is that we cannot do a prohibition. The initiated measure prevents you from prohibiting this within your community. So that's why we're pushing to get regulations in place, because you can't just say we're not going to allow them in the municipality. You have to allow them.
Question? The 1,000-foot buffer from a dispensary to a dispensary, but that doesn't apply to a manufacturing, testing, or cultivation, so we could have 3 cultivation buildings right next to each other since all the growing has to be indoors?
yes, so the buffers between the dispensaries only applies to dispensaries.
So we could have a manufacturing, a cultivation, and a testing facility all right next to each other?
Right.
Or
And I guess
multiple of them next to each other?
And as you can, I'll just kind of tell you the rationale behind
Okay.
that is that, and you might see this more in the licensing ordinance, is that they're not going to be able to advertise, to a significant extent
Right.
what
So
they
you might
are.
not know that that's what it is.
And
but-
those other types of facilities have other restrictions where they're not going to be able to be open to the public.
Correct.
So they're going to be they're going to
So
be
that-
less visible and less accessible.
Right,
So
the rationale, 1,000 feet, because of the visibility and public use.
Correct.
Well, they also kind of go hand in hand. So if you grow it, typically you're going to harvest it and move it over here and do whatever you do with it.
I'm just
Yep.
asking,
Yep.
we say 1,000 feet around one of the license types and not the other 3, and I just want to make
Yep.
sure that that's understood.
And that was the rationale when I was drafting it and
Okay.
putting it together, and the way that I've seen it from other communities. So I guess the council could certainly have other opinions on that, but that's the reason.
I think another good background to provide is a lot of the work that Justin put into this was based on information reviewed by some examples in Colorado as well as discussions with other cities across the state of South Dakota too. The other thing is when you're looking at those cultivation and testing facilities and manufacturing facilities, because of the restrictions on where some of these can go, you're really limited in where they could be potentially located in Mitchell as well. So those districts are going to kind of isolate where they're going to go anyway, so you don't want to make it too restrictive.
Will you kind of go through the maps one by one, kind of? Is that, or do you have something?
Yeah, well, I can touch on the last couple of issues here while Stephanie's kind of getting to the right spot here. But so the other two sections here that I haven't really touched on in the ordinance yet, there are a couple of factors that are laid out that would be additional criteria that council could consider when a request for a variance or a conditional use comes up that would be more specific to these types of operations. And then we do have a section that explicitly prohibits cannabis establishments in all the other zoning districts as well, so that there's no gray area. And then any cannabis establishment without a license would be prohibited in any zoning district as well. So I think with that, we can kind of walk through those maps a little bit and give you a little bit of an idea or answer questions. So as you start going through those, the blue areas would either be the TWC or HB districts where it would be a permitted use. Once you get to the map that has a downtown area that's going to be kind of a brownish color, those would be the districts where it's either a permitted use or a conditional use. Yeah. So kind of hard to make out, but on the left side of this screen, there's that brownish district that's outlined there. That would be the central business district, and that would be the conditional use area. So those are the total districts where it could possibly happen. Now, the other thing that you've got on the maps are these colored blocks. They're coordinated by the type of land use it is. You can see schools are yellow, churches green, childcare light blue, and a few other ones there. But those would be the businesses and the properties themselves. And then you'll see around those red buffer zones. So where you see yeah. So oh no. So we can just use this, start at the top actually. So this would be the, it's going to let me scroll now. Oh, we'll use the arrows. So this would be the bypass area and havens on the left side of the screen here. You can see that there's a big chunk of blue on the west side of the bypass, a little bit to the south there. You've got the green area that represents JP2, and then the large red buffer zone around that. So you can see when you start getting into some of these lots down here or on the edge over here, you might have a lot that barely has that buffer zone cross into it, but that would also exclude the whole lot. There was some discussion yesterday at Planning Commission about whether to consider 300-foot or 500-foot. In selecting the 300-foot and drafting the ordinance, we chose that because it represents the distance approximately of a city block. And especially when you start getting into the downtown area, zoom in here for you. So when you start getting into the downtown area, gotta let me scroll again. You can see that things are spaced kind of sporadically enough that it starts to eliminate quite a bit of area just at 300 feet. Do you have the 500-foot one? That's a good question. So after yesterday's meeting, we tried to, we got a mock-up of what 500-foot would look like, just for comparison purposes. And you can see that it is considerably more restrictive. You'd be isolated to just a couple of blocks in the downtown area, which is where it would be felt the most.
Justin, can I ask you a question? Doug Backlund's my name. Is this 300 feet or 500 feet, is that by the state law that you're going off of, or is this just an extra layer that the city's putting in?
No, so the 300-foot buffer zone would be the cities.
The cities, okay.
As I said, the 1,000-foot buffer that I was referring to before
That's
around
by state law,
schools
right?
was under the state law.
Is there a reason why the city's adding an extra layer versus what the voters voted on?
I guess it's very common from what I've seen in other communities to have buffer zones around the dispensaries themselves. And it's not dissimilar to...
You're talking 1,000 feet between the dispensaries though, right?
No, I'm talking about from certain other types of businesses as well.
Okay. All right,
So-
thank you.
So you can kind of see on that map that try this again. So trying to get your bearings here.
So it almost touches almost every blue area.
So the top here is 9th. You can see that there's probably one block that would be unaffected and maybe a half a block in a couple of spots there. The entire rest of the area is taken out until you get down to about the middle of between 1st and 2nd. And if you go north, basically everything north of 9th would be zoned out. If you did a 500 versus a 300, there's still quite a bit up here around the mall and where Shopko used to be, and a few other areas that would be able to be used at 300-foot buffer, but not a 500-foot buffer. Yeah, so I made a reference to this earlier, but I think this would probably be good to bring back up, is there were a few provisions in there to consider when getting conditional use or variance requests on these. One of those variance requests would be if there was a location within one of those buffer zones that the council still felt was appropriate to cite one of these, they could apply for a variance and still locate within one of those buffer zones, but they would have to come in and they would have to ask for the variance. They wouldn't just be able to go there.
Would they still go to the planning commission, or
Yeah, it would follow the normal variance and conditional use processes.
What zoning is that under, Justin, that you're just saying that there's permitted and then there's conditional? That,
Are you talking about the
the
buffer
actual
zones?
zoning,
or-
yeah, like you mentioned highway business and.
So, the-
PWC, industrial.
yeah, the-
So if one of those, I think what he's saying is if one of those were to touch an area that would prevent it from being used, they could request a variance and go through the variance process to try and get it, a variance to allow them to have a facility.
Yeah.
For instance, and I'm not picking on you, Doug, but I'm guessing the old Subway is your building yet, right?
Absolutely.
And-
Go to
and-
500 block of South Sanborn, and I'll show you what I'm talking about.
And there's a church right in that area. But Sanborn is kind of a business district. So,
And it touches my property, but it'd be it's just a spare parking lot that I own. But it would make my building's out of the 300 feet, but my property's within it, so I couldn't do it. Which doesn't make any sense to me, I guess.
So Justin, could he come for a conditional use or no?
So if you're talking Sanborn,
50, yeah,
I
it'd
don't
be,
know if it's HB or TWC.
it's HHB.
So HB, you would not need a conditional use, it'd be a permitted use there.
But I'm within
But-
your 300 feet.
So if it's for a dispensary, which remember, dispensaries are the only ones that have that buffer zone that applies to them. If
Yep.
it was going to be a dispensary, that there would have to be a variance request if it fell within that buffer zone.
Yep.
So it
Scroll up there,
might
Steph,
be a
sorry.
permitted use, but it would still need a variance for the distance in the buffer zone.
because it touches a church, yes.
Yeah.
Yeah, and I mean, you know,
And for-
the church is there, and I mean, there's a casino and a bar right next to the church. So why are we restricting this more than that is what I'm kind of getting at.
And then the other scenario that you might see is if you're downtown in the central business district, remember, that's a conditional use to locate there.
Sanborn.
Yep, Sanborn, you're on Burr.
You gotta go about 6 blocks that way,
You got to move down, I think.
meet a year.
This is why I don't run the maps. I didn't create them, I don't know which page.
Of all the days not to have a mouse.
I know, and then we don't have a mouse either, so that's.
Keep going, keep going.
You're up.
Yeah, keep going.
That's the bike.
No, you think you got one more, maybe? Oh, that's the airport one.
That's late.
So which page is it on?
Well,
Page 4. Page 4, okay.
or one.
Southwest corner.
I was gonna say, I think it's page 1, to be honest with you.
Yeah, page one was the one. Page one on the top right side. Scroll up a little bit.
Yep, now scroll in right there.
Yep.
But
right
see, there's 3 lots there, and my south lot, which is just a parking lot, would make it so I'd have to come in and apply for a variance. Well, I could just opt to sell the property, and then I wouldn't have that option, I guess, or I wouldn't have to worry about it. But I don't think I should have to do that, so you get, you know, so I don't have to go through the permitting process. I don't know, it's just something to think about, I guess, guys, you know? I guess the other thing that kind of gets me is, I mean, you know, there's a church like in the old Moonlight Building downtown. They plop churches anywhere, and I'm not opposed to that by any means. I just am making a case that, hey, it goes both ways, you know? And what happens like if a dispensary is in an area and then a church wants to go in next door?
That wouldn't, it'd be grandfathered in.
Would-
It
yeah.
wouldn't have an effect on.
Oh,
If
there is a
it's-
clause for that? Okay.
Yep, if it's there first, then it would stay.
Gotcha. All right, thank you, guys.
And then I started bringing this up here, but the only other scenario that you might have to deal with is if somebody wanted to come in the central business district, they're going to have to come in and request a conditional use. And at that same time, given how many buffer zones there are downtown, they might have to request a variance for the buffer zone at the same time.
we know this isn't perfect, and there will have to most likely be amendments down the road, but we've got to start somewhere, and we need to have something in place before July 1st.
Justin, is
So-
there a article in the ordinance that deals with dispensaries and liquor in the same locale? If I owned a bar, could I also have a dispensary?
It wouldn't be in the zoning, but the licensing ordinance that we'd be discussing next should address that. And that would not, it should not be permitted. So that's not part of this one, but it would be touched on under the
Right.
licensing one.
Keep in mind, we're only dealing with medical marijuana at this stage, which pharmacies do not sell this because it's not an FDA-approved drug. So it gets dispensed by others, if you will. Through, I'm not even sure how this all flies together. Apparently, a doctor gives you a certificate that allows you to have it, and
I
it's
think,
not a perfect world, but we need to have some ordinance in place to cover this. So what you're talking about really is more along the lines of recreation, which has not been allowed.
If I had a doctor's
Note,
note, and I happen to be in a bar, could I expect to get, that was my question, are they allowing liquor?
that will
and
be
a
in the next,
dispensary
that'll be
same
in the
deal?
next ordinance we discuss.
That was my question.
and I guess the only other thing that I would add on here is when we were discussing the 300 versus 500 foot yesterday at Planning Commission, I did bring up the point that you do have to be a little bit careful at times to make sure that your zoning is not being overly restrictive. You can get into problems there. I'm not saying that we'd have that problem one way or the other if you chose 500 foot over 300 foot, but it seemed to me that the 300 foot was kind of striking a balance between creating a small buffer zone around those sensitive institutions, but not completely eliminating large areas.
Justin, is there any cities in South Dakota that have zero? No 300 foot? Is there any of them?
I don't know that anybody else has adopted anything yet. I know that in most of the other cities that I've been discussing this with, I think most of them intend to have some kind of a buffer for dispensaries. I don't know that they would be implementing them for the other types of cannabis establishments, but I believe that most of them will be doing some kind of a buffer around the dispensaries themselves. And some might be doing more than 300, some might be doing less.
Sure.
I can't say for sure.
All right, thank you.
I was just curious if Mike Coster had any, being the law enforcement, if there's any concern on his part with any of how it's read. I'm sure he does.
Well, as the mayor has said, I mean, we need to have something in place. Otherwise, the Wild West. I mean, you'll have no say as to where any of this goes. It has been voted on by the voters of South Dakota. It is going to happen. Essentially, it's what it is. So, I looked through what Justin has put together. I think it's a fair balance, and I think we should consider it.
Justin, just one more question for you. So with the no-fly zone in the buffer area, you're kind of devaluing that property, considering the property that'd be right next door to it would be valued more because a dispensary would be allowed. Are my taxes going to be lowered because of that? Or at a reduced rate compared to my neighbor or across the street from me?
I wouldn't expect that to happen.
Neither would I, but do you think that's fair?
I guess I won't venture a guess on that. I can't say.
right.
I don't think I necessarily agree with your assumption that it would devalue the property, but I guess if that's a concern that you had.
Well, that's what happened in Sioux Falls when they imposed this on casinos, the 1,000-foot rule and stuff, just so you guys know. The city of Sioux Falls went through this with video lottery.
And it's not dissimilar from what we already have in place for adult-oriented businesses in the city as well.
Pam Bathke, I just have a question about parks and playgrounds. Is there a reason? I don't think they're included as far as having a buffer zone. Is there a reason?
They were not. Most parks and playgrounds are kind of tucked into residential zones, and they're already prohibited from being in residential zones. So,
Okay, I was thinking Hitchcock had some blue around it somewhere, but I'd have to pull it back up.
yeah, former railroad land.
That's Northwestern Public Services area. So down in the area where Dry Run Creek is, Hitchcock, that's where the TWC is. But Hitchcock gets touched by part of the buffer, the red from Longfellow Schools.
And that was another
We
reason
allow
is
Hitchcock.
oftentimes there were already something in the area that was creating a buffer, so.
Further discussion, comments?
Hi, Jason Bates. I just have a question out of curiosity. The old Q107 building is now a church. It's not your traditional church structure like, you know, they're just renting a building for a church. And also the old Moonlight. And then also, I believe the old, looks like a palace. What's that called? Yeah.
Oh, the old Doll Museum across the
Yeah,
street?
yeah. So those are now like churches.
I don't know that that's a church. It's got a religious function, but not,
Right.
I guess, I don't know. We'd have to look into that.
Yeah, I'm just saying that, you know, they're renting a building and made a church. They're not your traditional structure, so how does that work? You have to wait until,
Well, they don't, I
if they
don't think
move.
anything says it has to be a traditional structure if it's
Right.
a church.
So if they
so-
moved out, that zoning would change.
Right, so the ones that you're referring to further down Main Street are included on the map here.
Right. I just thought that was a question because it's kind of a
Yeah,
just
so
rented building.
it's kind of based off of what the primary function of the structure of the property is.
Right.
So right now, I guess the primary function at those locations is the church.
Sure.
If they did move out at a later date, then
Right.
it's not really a church anymore.
I just thought that might be a question that might pop up. And then what about that Fifth and Main, that's kind of a kids hangout place? That's probably,
That's,
Yeah,
that's right, okay.
Yeah, I think that was included on there.
Okay, I just thought that might pop up since it's not a, church building, so to speak.
I think
Yeah,
it is, actually.
it-
Oops,
yep,
I
it
just
is.
lost it. It's this one right here, I
Yep.
believe, right?
Yep, correct.
And then just keeping in mind that the central business district is, like Justin said, conditional use permit. So all of those requests are going to have to come to council, to the planning and zoning board. And they could request, if the buffer zone is really only touching the other side of that block, and they thought it would make sense to have it not facing Main Street, they would have the ability to do a variance at that time if they wanted to, if that 300
Right,
feet was causing an issue.
right. So, thank you.
Like maybe this would, sorry, my microphone's not really working. Like maybe this one here where it's hitting, really that 300 feet is at the backside of, hitting more of the backside of the block versus the front side of the Main Street facing businesses. You might have individual situations like that come up.
You may have addressed this already, Justin, but is there a reason why it's conditional in central business?
I think the reason behind that was it's just much more condensed, and the types of operations that you could potentially have in there, especially if it were to be a cultivation facility or something like that, there's more concern there about the actual operation and it being so close to other structures that you kind of want to take a closer look at all of those that would be coming in that district.
Plus, it makes sense, it kind of makes sense to have a dispensary or a facility on Main Street down in the central business. But as you can see, we have churches and things that prohibit it all over down there. So that's why the ability to have a conditional use and ask for a variance made sense.
Well, I want to reiterate the fact that this was a state election. We didn't ask for this to be put on our plate. This was a state election that got voted in. And if you're concerned about the dispensaries and where they're going to go, we're actually are going with the rules that Justin kind of laid out and as we're discussing here, it's going to limit the number of dispensaries there's going to be in town. And so if we didn't do anything, it would fall under state law. And state law, it's only prohibited, I believe, with the schools. So you could have 5, 6 in a row if you wanted to. So what we're trying to do is at least trying to get control of this and actually have a licensing process. And then that way we can monitor it. And I also believe, too, Mayor, that if we did nothing, the taxes that's going to be generated through this would be strictly state and the city would not receive anything, or how would that work?
No, I think we would still collect their sales tax, the typical sales tax, but
I don't believe you can tax the medical marijuana. It would be just recreational when that comes around.
Oh, that's the
yeah, we don't know what's going to happen relative to that yet. I don't think.
Yeah.
Do we, Justin?
Let me back up a little bit. So I don't think we've heard definitively one way or the other whether there's going to be sales tax on the medical sales or not. I've heard both. I've heard it go both ways, and I don't think we've got a definite answer on that yet. But if we don't adopt our licensing ordinance, then we would not be able to receive any kind of revenue from the licensing side of this.
Oh, sure.
Whatever that might be would just go directly through the state.
Okay. But again, to reiterate, the point is we're actually taking control of our city and making sure that we're not having too many according to whoever. But at least we're going to be able to say yes, yay or nay on the licenses, and then also the conditional uses in those areas, and then that could be taken up by the Planning Commission and the City Council. So at least people are going to have voices to a certain degree of where these can be placed.
Correct.
Yeah, excuse me just a second, though. You're talking variances and conditional uses, and remember, they're not the same. A variance allows you to come in to do something. A conditional use allows you, as a council and us as a planning commission, to say, we would like to see these conditions on this use. So keep that in mind, that you're looking at two different things here, folks.
Correct. And the conditional use would be downtown where you don't touch a facility like a church or a school or preschool. The variance would be needed if you do touch that. So if, for instance, if you wanted to put one on between 3rd and 4th and Main on the west side of the road, obviously the Methodist church is there.
Okay?
It's not allowed. So you would need a variance.
Yep.
Not just a conditional use.
Yep,
Yeah,
and
you'd
then
actually need
and then
both in that
after you
case.
got that variance, we could put a condition on it, recommend to you guys, that no Sunday sales, no Wednesday sales, because that's a church day. You know, there's all kinds of things that we can perhaps look at once we get to that point.
Right.
But the idea is, we've got to have some direction here as a planning commission, and so do you as a council. And that's what Justin is doing here for you right now, I believe. And if you don't know me, I'm Jay Larson. I've been chairman of the City Planning Commission for longer than either of us care to know.
Sorry, I have one more question. So, do you...
Say your name again.
Jason Bates, sorry. Do you know the variances, if this would turn into regular recreational sales? Are you going to run into some trouble if your variance is, like, because these medical places probably, if it changes to recreational, they probably will be able to start selling for both, I would imagine.
If it goes to recreation, the ordinance would have to be amended to adopt recreational use.
Right.
So at this point, we're only addressing medical use. So no, we're not looking at anything relative to recreational. It would be amendable if recreation were to come in, and who knows what's going to, that's at the Supreme Court right now. And I would imagine it'll be voted on again in November if the Supreme
Right.
Court throws it out, so.
I just thought if the variances weren't similar, we might run into some trouble down the road where, you know, now the medical turns into recreational, now they're too close to.
This whole exercise will happen once again, if recreational gets approved.
Yeah, so we did draft this with that possibility in mind, but that doesn't mean that this is just going to automatically roll into it. There will be some changes that are necessary down the road if it ever goes to recreational.
And I guess the other point to keep in mind is that as with any other zoning ordinance that council considers, you may get into this and find you need to tweak it also as those requests start coming in. So, and then you would go through the ordinance approval process just like you are now.
Move to place ordinance 2021-06 on first reading.
I have a motion by Mr. Allen,
Second.
second by Mr. Rice. Further discussion. Anybody else in the audience want to address this? Okay. All those in favor of the motion signify by saying aye. Aye. Opposed, nay. Motion carried. First reading on ordinance 2021-07, creating licensing regulations for cannabis establishments. All right, Mr. Johnson, let's go with this one.
All right, well, I'd like to give you a summary of this one, but I don't know that I can. There's quite a bit to it, but I'll try to cover the basic topics here. So this ordinance is more focused on the licensing aspect of cannabis establishments, setting out how those licenses are going to function, how they'll be issued, how the applications are considered, all the administrative stuff like that. And then it also places a number of regulations in place as to the cannabis establishments themselves and some of their operational requirements and things of that nature. So as we start walking through here, again, the first couple of sections are kind of basic. Establishing the licenses, obviously everybody's going to be required to have one of these licenses to operate a cannabis establishment. We break it down into the 4 types of businesses and require a license for each one of those. So say somebody wants to come in and they want to cultivate, they want to process, they want to test, and they want to sell, they're going to have to get 4 different licenses to do those 4 separate activities. A person is not prohibited from having more than one type of license. The licenses are all good for a year, and they can be renewed.
With the exception of just dispensaries, you can only carry 1 dispensary license, right? Or can you have multiple?
I don't think that you'd be prevented from having more than 1 dispensary license, but you could only have 1 at 1 location.
Okay.
So a person might have a dispensary license for the north side of town and potentially another one for the south side of town.
So when we say the limit is 5, that's 5 total licenses,
Correct.
no matter what type? So,
Mm,
so it's not, there's 4 different licenses defined because one's cultivation, one's testing, one's manufacturing, and one's dispensary. And we say so it's not 5 of each of those?
No, so,
It's 5 total. So
no.
No, it's 5 dispensary
So it's 5
licenses.
dispensaries.
how many of the others?
You're
The
unlimited on.
the others are not
Ah.
capped at all, so you could potentially have 100 of each. The only ones that are capped are the dispensaries, again, and the rationale there is those are the only ones that are directly selling to the public. The other ones are more of silent operations and, wholesaling and farming themselves, so. We also built in some language about, I lost my place. Yeah, so again, the licenses, they're good for a calendar year, so you might have one issued in the middle of the year, but then if that's the case, it's good from the time that it's issued up until the December 31st, and then they would have to renew it for the following calendar year. It's not good for 12 months from the date that they receive it. Next section talks a bit about the caps that we just discussed. And then we go into the application process, which much of that is similar to other applications that we process. Some of the information that's required might be a little bit more tailored to the cannabis establishments versus like ride-share licenses or something like that. We go through and lay out the process that the council will act on them, which is, again, is similar to other types of licenses. The one thing that's a little bit different there is I developed some additional procedures for a license class that's capped. So instead of doing it on a first-come, first-served basis, when you've got that cap on dispensaries that we would be adopting here, instead of it just being open and first come, first served, what we would do is we would basically do it like we do sealed bids, where we'd put out a notice, people would have a window to submit their applications, and then you review those applications, you discard or reject any ones that aren't complete. The ones that are complete get to go on to the next stage, and that would be a lottery where you set the order in which those applications are considered and acted on by the council, and then you start working through those applications in that order until you hit the cap or you run out of licenses, so, or run out of applications. So that part would be a little bit different than the way we're handling anything, but I guess from what I saw in a couple of other communities, it's just another way to handle that cap issue. We also lay out the renewal process, and for those renewal applications, if it happens to be that capped category, it's not like applying for a new license. You give those ones that have a license in a capped category priority over any new applications. So, you know, those businesses that are operating don't have to worry, well, am I going to end up winning the lottery next year and being able to get a license to continue operation? Once they've got it, they can keep it as long as they get it renewed and follow those procedures, and there aren't any major reasons that the council would not approve their license. We also put in some conditions on transferring and updating the licenses and the application, or the information that would be contained in the application, such as the ownership requirements and things like that. We put in a provision that a licensee has to keep their license in active use, and we define that as not having it be inactive for more than 14 consecutive days or 60 cumulative days out of the year. So
I got a question there. So if I'm closed on Sundays and holidays, I have a cumulative more than 60 days that I'm not in operation? If I'm closed Sundays and Mondays, I'm way over.
Yep, I guess that's a fair point. We don't define that in there currently. The way that the language is right now, it's not mandatory. It can be declared, and then if it is declared, ultimately it comes to the city council to make a final determination on whether that inactivity would warrant suspension or revocation.
Same thing if I'm a snowbird and I go to Arizona for 6 weeks in the winter and close my shop, I'm certainly closed for more than 14 consecutive days.
Yeah.
And there's businesses that do that.
Right, and I think the only time that this is really going to be a concern, I guess, would be is if you've got the capped category where, you know, you're limited to 5 licenses throughout the whole town, but then nobody happens to be open or something along those lines. And
Or if you have
I mean, there's a potential issue there, and this, I guess, is an attempt to address that potential issue.
And keeping in mind, it just gives council the ability to make a decision to have one that might be open more than 6 weeks out of the year, where you might have 2 businesses.
Right. So it's not mandatory. It just it gives the ability for that to come to council if it ever becomes an issue. Because I know that we've had that issue come up with liquor licenses where a business is not, the license is not active, and if it's not active for a certain period of time, it lapses. So,
and we're trying to make this so it doesn't become a commodity that somebody buys and holds and increases the price. Go ahead.
Jason Bates. So is there something that can stop somebody from setting up in a county? And because there's a cap, well, there was a cap on liquor licenses too, and some rich people figured out a way to annex liquor licenses into town, which made
The county has, that would be their regulations? And
well, my concern is they annexed quite a few liquor licenses in, and there's way more than we probably should have in town. Is that something that could happen with the?
I would say no. I know that the county is going to have their own system and own ordinances that they're adopting to address marijuana establishments in the county. But say that there was a business on the edge of town that had a county license and they annexed into the city, I don't believe that they'd be able to just continue operations because they wouldn't have a city license.
Well, the county licenses got pulled into the city and turned them into city licenses.
liquor's a whole different animal.
I know that, but it could happen. I mean, somebody could try.
Right, and that continues to happen. People get liquor licenses in Davidson County because I think the state gives them a new liquor license every time somebody annexes into the city.
So the liquor licenses, bottom line is they're processed differently than the way that these are.
Right.
So
I can
these
just-
ones, to operate in the city, you have to have a city license.
Right,
It's not good enough just to have one through the state.
Right, but I could see people trying to do this because there's a cap.
They're going to be in for a rude awakening if they
Okay.
do that.
I wish you'd have done that with liquor licenses.
Yeah, we,
So from there, we did set out, go ahead.
And under the section for the capped licenses, so I'm on page 6, section C, item 5, where it talks about such review shall be completed within 5 business days from the established deadline to receive applications. Is that the review by the finance office, or is that the review by the council?
That would be the review by the finance office. Just kind of that initial.
The way the wording is in there, it's not real clear who's doing that review in 5 days. Because there's no way the council's going to be able to look at those and make a review in 5 days.
Right. So that's the intent when I drafted it, was that for it to be the initial review by
And that's-
finance
The finance
office.
office does that as they're looking at the applications
Yep.
under a cap situation. Okay.
And I guess if you read the overall structure of it, it makes more sense.
Yes,
I
but
think
if you read it independently,
Yeah.
it may be a question. Okay.
Yeah, I can understand that, so. I think we were down section 8, where section 8, we just start laying out the various fees. I think a lot of cities that I've talked to would like to charge more than the 5,000, but the state statutes do limit us to charging a reasonable fee, but it does not define that. But it does state in the state statute that the state has a licensing fee of $5,000. So I think that's going to
That's where 5,000 came from?
That's basically going to be our safe harbor, where I think we don't really have to justify additional costs or administration over that amount. I think you're pretty safe charging 5,000.
Just, would that be prorated if I open in October?
No, it would not.
November?
No.
5,000 fee, and then on January 1st, another 5,000.
That's correct.
Truthfully, I think 5,000 is too cheap myself, but that's my opinion.
And I'm not saying that you can't charge more, but I am saying that charging more than 5,000 carries more risk. Risk that you get sued by somebody who's interested, saying that your fee is not reasonable, and you get your statutory scheme thrown out in court. And preventing our ordinances from remaining in place.
And since the state fee is 5,000, you can pretty easily say that we're charging the same as the state.
So is it a $10,000 fee then per license?
well, it'd be 5,000 for the city, or 5,000 for the state, which you have to have first.
Yep.
And then 5,000 for the city, so yes, $10,000, yes. And then if you want to grow, if you want to cultivate, test, process, each one of those is $5,000.
And I guess I can't say that for sure, because the state has until late October to publish all their rules and get all that in place, but there is one section in there that refers to a $5,000 fee, so that's what I worked off of when setting these amounts.
And if they change their price, we can, down the road, we can raise ours.
Yep, or if the state clarifies that we can charge more, we could do that too, so. And again, we did build in language here that you can modify those rates in the future by resolution, so you don't have to go through the full process of revising the ordinance.
So if they're doing all four, it's 40,000, correct?
For all four from the city would be 20.
20,000.
I don't know what it would be
I
from
don't know
the
how the
state.
state does theirs for sure. I don't know that the state knows how they do theirs for sure yet. If you have one license from the state, it may very well allow you to do whichever one you want, but here in the city, you would have to buy a $5,000 license for each thing you were doing with it. So the state does not have to have, it'll go into law July 1st, but they don't have to have all their rules and regulations set until roughly November 1st or the end of October, somewhere in there. So we were hoping they had a little bit more guidance, but hey,
And really what we're trying to be proactive about is, although they have till October, they could come in July 2nd and say, here's our rules.
yes.
So we need to have something in place in case that's the case.
And I did kind of gloss over that part earlier in discussing the application portions. There is a section tucked in there that says that we will not receive applications until the state issues their rules. So until they do that, we're not even going to take any applications in at all.
Justin, back on the application part, and I've got a question there, and it's page 5, number 8. Confirmation that the the applicant has conducted background checks and criminal history for each officer, board member, agent, volunteer, blah, 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 at the time of the application. Well, if I'm applying, I'm going to say I'm the only member, and I did a background check on myself, and I get the application, and then I hire everybody.
Yep.
And, I mean, that's typically what happens, and then if we're worried of bad actors being hired in, they're hired in after the fact that the application's been done.
Yeah.
So there's no going forward. So I hire new employees, fire new employees. We don't have any, there's nothing for criminal background or anything on
Not
any of that.
necessarily, because we do put the obligation in there later that they have to keep that application information up to date. So, you know.
I'm not saying we should, I'm just saying
Yeah,
that's
theoretically, they have a continuing duty to making sure that they're
from the
conducting
application
that.
process to
Yeah.
make sure.
The state in their process could require
You're right.
something along that line too.
Right, and that language mirrors a state requirement, so that's where that portion came from. But yes, they should theoretically have a continuing duty to make sure they're doing that any time that they have the license, not just when they're applying. They don't have to, necessarily give us the results of each one that they're conducting or anything like that, but they have to be doing it.
Okay. Because, I mean, we have lots of businesses in town, we don't require that from people, and I'm just trying to make sure there's balance here that this is a business, so don't want to go overboard
Yeah,
one way or the other.
I don't think it should not be any more restrictive than what they'd be required to do under the state law.
And then keep it in mind, you have an annual review of your
Correct.
license holders.
Like,
So if
yep.
you have an issue, you can address that at renewal time.
Correct.
Is there going to be a limit on, like, if they get caught doing something 2 or 3 times illegally, you can take their license away then, or?
Yep, so that later down in the later sections here, we've got some suspension and revocation provisions. And, there's lots of different ways that you can invoke that section, including violating any provisions here in this ordinance, violating state law, and there's a few other specific things listed there too, but there most definitely are ways that the license can be suspended or revoked if there's problems.
Is that by us or the feds, Justin?
So based on the language in the state statute, I don't think that we can rely on any federal illegality. So with it still being a controlled substance at the federal level, we can't say that they're violating federal law and revoke their license because of that. But if it's a violation of state law or a violation of our ordinance, that would come into play.
We do require security cameras on premises for these too. Yep. So, and we can even revoke it if they don't maintain security cameras on the premises.
So I won't go through all of the obligations that we've listed here, but there's various different aspects of their operations that would be touched on in one way or another here. Odor control, security, what's visible, security cameras, record keeping, just various topics that there are covered, who can come into the facility, who can work. I guess if there's any specific questions on those, we can kind of cover them, but I'm not going to go through each one.
On, it's page 10, number 8, each license shall provide adequate security. Who's determining or defining adequate? Are we going to, if they, page 10, number 8? Yeah. Are we going to review their security system, or it just has to be adequate?
I think it
Adequate based on the other definitions in there of being able to retrieve footage and that type of stuff?
Right, and keep in mind that they basically need to give a synopsis when they're making their application of their operating procedures.
And those will be reviewed.
So you can
in the
review those at
application.
that time. If they're not in compliance with those, or if it ends up being insufficient, you could consider that a violation and then potentially kick yourself over into the suspension and revocation procedures if there was some kind of serious concern.
Okay. And then I'm on the same page, and it's down under the additional requirements. And part of it's letting the people in, so they come in and a confirmed eligible customer. So I come in and there's a front lobby, and I have to wait in there, and do I have to, before I can go into the retail spot, I have to prove that I have a cannabis card, and if I don't have a cannabis card, I can't go, only cannabis card holders can go into the retail section?
Yes, so they'd either need to have a card themselves, or they'd have to be accompanying somebody that has a card that they're, responsible or authorized to go with, because
So
it's
a
not.
parent and a child, for instance?
Right, so a guardian, or I think there's a special term that the state statute uses, but.
But I can't just,
Somebody with.
No,
I just can't
yeah,
walk in and say, hey, I want to
You're-
come in the retail area.
Yep, average Joe off the street can't go in.
And so if I go in that front area and I can get out that front area,
Right,
but I can't proceed in. But so
Right.
I'm not trapped in that front area. I can exit that front
Right.
area at any time.
yep,
Okay.
Yeah, that'd be required by fire codes.
Right.
yep. So, I mean, it's kind of like a security checkpoint at an airport where, you get through the checkpoint, and then when you come back out, you kind of go through the sets of doors.
Yep.
So that nobody can come back through that way.
So each establishment, if there are the dispensaries, will have to have that set up in place as part of, otherwise they won't get a license.
Right.
It just begs the question then, so if I'm doing a cultivation or testing or manufacturing, do I have to have a secure front lobby, or I'm an employee at a cultivation facility, I have no cannabis medical card because I don't require one, but I can work there. And so I have access all the time, and there's no restrictions or anything like that. Same thing at testing or manufacturing.
Thought I had language in there saying
I'm
that
just
they,
asking, I didn't remember reading that as far as those facilities.
I believe I had language in there that they need to ensure that unauthorized personnel aren't within the
411.
cultivation, products manufacturing, and testing.
411.13? Okay.
Unauthorized conduct relating cannabis. I think is what you're looking for.
No. My question is, so I'm a grower and tester, and the people that come in and work for me, my facility is, I don't have any security. And anybody can come in and out. Is that an issue, not an issue, or should we address it, not address it? I don't care.
Well,
I'm just,
I would guess an employer's going to pay attention.
And
You know,
the
we don't-
employers-
We don't tell banks what, yeah, you know.
Correct.
Don't
So
let them in the
that's-
vault.
So, Steve, the one I'm referring to is, looks like page 10, number 10 at the top of the page. Licensee shall not permit the general public to access any part of a cannabis establishment except where such access is permitted by law. So those should still be secured
Right.
areas.
And the good example, we don't tell banks they have to have
Right.
security.
You know.
Or not let anybody in the vault.
Yeah,
and
we're
that
not in the
type of
habit
stuff.
of telling people how to run their business,
Right,
I guess, is the
right.
bottom line.
Jason Bates, does the state have a limit to how much a person can buy? Like, what if I had a card and Bob came over and we decided to share it, and I need to
We
go
don't
get
know
more?
yet. We don't know yet. They haven't,
okay.
they haven't got all that out. Mr. Coster, you got any idea on that?
I believe that there is a limit on the amount that a person can possess and still receive the immunity under the state statute, but I don't know that amount off the top of my head. For some reason, I want to say 3 ounces, but
Holy cow,
I
that's
don't.
a lot.
So I would assume that a person would not be able to purchase more than that amount. And I can try to find that here, depending on how good my internet works.
One, 3 ounces? Okay, question?
To have in your possession, I think, right?
Yeah, that's what it says. Under the
So-
medical patients may possess a maximum of 3 ounces of marijuana.
Yes, if you use 3 ounces a day, you could get 3
And then it
ounces a
says-
day, but that's a lot
Then
of
it says the
marijuana.
Department of Health is required to establish a limit on the quantity of cannabis products a person may possess.
So I,
You couldn't go to 5 different dispensaries and buy 3 from each one?
No, you can
I-
only have 3 ounces in your possession.
right, and I don't know how that's going to work. I think that's probably going to depend how the state implements it,
Yeah.
but
Cross-check system. Question, and I'm on page 13 and 41113, the unauthorized. Item 3, it's smoking cannabis on any form, public transportation, et cetera, or on property of any establishment. So you can eat it, but you just can't smoke it?
that's language basically out of the state statute. I guess it's more noticeable when it's smoked, and it's also more likely to,
But so
I guess, carry over to another
If I have
person.
a card and I have an edible and I'm taking the Palace Transit bus and I eat my edible,
Your gummies are okay on there.
That would not be prohibited by the ordinance.
got it. It might be prohibited by something else. But,
Yeah.
okay, I'm just asking, reading what we wrote.
There will be tweaking of this as we go, I'm sure.
Can't have secondhand gummy bear inhalation, I guess, so.
So, okay, I'm just thinking through the licensing process and the building requirements and all that kind of, so we would have the opportunity from the fire marshal standpoint and from building inspector standpoint and all of that to check the buildings before licenses are allowed.
Yes, so that's going to be part of the process here. We built in some language for both the building and fire official to basically draw from other sections of the building code. You know, when a building comes in, it might be a certain occupancy type, but due to the way that they're operating, there might be a relevant portion from a different building type that you might want to apply there. So we tried to give them a little bit more latitude to pull from those other categories, even though it might not strictly apply to the location or something like that. So both the building official and the fire official should have a little bit more flexibility to address those hazards. And then we did also require fire sprinklers systems for all of all of the cannabis establishments, so.
And I think you said before, no city licenses will be considered until the state gets their stuff done. Right?
Correct, yep, so we will not even accept an application until the state has issued their rules. Could be any time up to late October.
July 1.
They've got that much time, but yeah, it could be July 1st, you know, there's no way of knowing when they'll release them, but we're not going to accept any applications until that time. And then, you know, with the special procedures that we've got in place for dispensaries and that class being capped, it won't be until that time that we put out the invitation for applications and start going through the lottery procedure and start considering those, so.
And that's when this will be tweaked again.
It could be. You could tweak it ahead of that time, or
About that time, they'll authorize recreation.
it'd be nice, you know, if we did end up getting any more information on what the state's going to do before they actually release them, then that would give us an opportunity to make adjustments. But the way that the state's been doing it so far, I don't know that we'll get any advance notice.
Can recreational walk down the street and smoke it?
Oh, we don't know. We have no idea on any of that. I think you did some of this, you looked at what Colorado was doing too.
Yeah, you would not be able to do smoking it, you know, it's prohibited to smoke it at any public place under the ordinance right now, so.
That'd be like tobacco.
It'd be similar to that. What about outside? If it's open to the public, it would not be, you could not smoke.
So if we catch somebody, Mr. Coster, smoking it outside down here in front of the courthouse, what will you do? What will you propose a fine to him for?
I would assume we're going to deal with it just like we would cigarettes. You know, what you can and cannot smoke in those public areas as far as the enforcement.
It's like halftime of a basketball, and they go out and have a cigarette in front of the Corn Palace, could they?
It would be more restrictive than your standard cigarette. Well, we know our portion of it. I don't know what the state could put in additional rules and make it more, or I guess if they make it less restrictive, that's a whole other bridge we'd have to cross. But the way that it sits right now, smoking would be prohibited at any public place or any place that's open to the public.
I've got another scenario question. So we have a license issued by the city and the state, and it's November. And I want to open my dispensary. But if I try and buy edibles or anything else from Colorado and ship them to South Dakota, I've broken federal law. So how do I get product into my dispensary? It has to only be grown and processed in South Dakota?
I don't think I can answer that for you. I don't know how they would be doing it.
Because I can't buy edibles in Colorado and ship them to South Dakota.
But you might be able to go get them and bring them back yourself.
That interstate transportation is not allowed. Kansas and Nebraska are picking up plenty of people driving across I-80 from Colorado.
How they figure to do this.
Yeah, I mean, the state law provisions basically aren't going to care whether you're bringing it over state lines. What the federal government might say about that is a different story, but that's not a factor as to the state law or a factor to our ordinance.
Be interested to hear what other states went through in that time frame.
I am quite certain that they will find a way.
Yes. They can't regulate it now. Hell, it comes.
Which I guess raises another question. The laws go into place July 1st. A person can grow or sell it at a dispensary until the state starts issuing licenses or they get locally licensed. But the individual's immunity from prosecution or their protection, that starts July 1st. So theoretically, it doesn't matter how they get it. They're entitled to its use as long as they're...
From the state standpoint.
Or from the local standpoint.
But it's still
as to
illegal
the-
federally.
As to the individual, it doesn't matter. So, you know, if a person's got their card, or they've got the certification from their doctor as of July 1st, it doesn't matter to us how they got it. We can't, they're not going to be able to be prosecuted as long as they're complying with the state statutes.
So remind me, if we approve this tonight, then our the second reading is June 2nd?
Yep. Next Wednesday, June 2nd, that's for the licensing and the zoning ordinance.
Okay, and obviously some people are going to be seeing this and reading this for the first time, so we're probably going to get a lot of comments on it. But as usual, we normally give everything a first reading, and so I'm going to go ahead and make that motion on ordinance 21-7.
Second.
Okay, we have a motion by Mr. Smith, second by Mr. McCardle. Further discussion? Anybody else want to address this from the audience? Nobody in the chamber wants to bring this up? All right. Okay, all those in favor of the motion signify by saying aye. Aye. Opposed, nay. Motion carried. We're adjourned.